Hi, Ellen Freedman here, Law Practice Manager for the Pennsylvania Bar Association. I get a lot of calls on the hotline asking me about suing clients for unpaid fees. And there are a number of considerations that you need to take into account. Number one, is there going to be a risk of a countersuit for malpractice? You may or may not have insurance coverage that covers countersuits for malpractice. Increasingly, that's being eliminated from policy, so you want to check your policy carefully. And you want to make sure that your I's are dotted and your T's are crossed. You want to make sure that there is not any restriction in your malpractice policy for that, and you want to make sure that you understand before you undertake a suit that if you do get countersued for malpractice, even if it's covered by insurance, it is going to affect your future insurance premiums regardless of whether there's a payout involved or not. You need to have somebody do an objective appraisal, perhaps an attorney at your firm who does not have a dog in the race, or an outside attorney who you might ultimately use to do the lawsuit, and have them look and see if you have your ducks in a row, did you get the best possible outcome, and so forth and so on. You want to look at your outstanding debt, the amount that the client owes you, and compare it to the deductible that you have. If you have $7,000 outstanding, that may seem extremely significant to you, but if your deductible is $50,000 and there's a countersuit, I can assure you that the cost for you to be defended will run through that $50,000 deductible inside of 2 months. So you have to carefully weigh the exposure for your deductible versus the amount of money you're ultimately going to collect, no matter how emotionally sure you are that you deserve that money. There is a comment to an ABA rule 1.5 that talks about a dispute resolution, and if there is any method of resolving a dispute over a bill with a client that does not involve suing the client for fees, you are required to do that. If the local bar association, your county bar association, has a dispute resolution methodology, you should always use that in accordance with comment to ABA Rule 1.5. Never take an adversarial position to the client when there's other methodologies you could employ which would resolve a dispute over the bill. Thank you for listening.